will have lost the verdict in the second trial, and it will be difficult to argue that the grant of a new trial was an abuse of discretion. Some commentators have called for more robust review of judgments granting or denying a motion for a new trial. C. Robertson, Judging Jury Verdicts, 83. Tull.L. Revelation 157, 217-18, 2008. 5. Suppose a verdict has been set aside and a new trial granted. If the jury in the second trial returns a verdict similar to the one rendered in the first action, may the court again order a new trial on the ground that the verdict is against the weight of the evidence. 5. The power to grant conditional and partial new trials. Fick H. v. Manger. Supreme Court of New Jersey, 1957. 24 NJ 66, 130.2d 815. Jacobs, J. The plaintiff suffered serious injuries in an automobile accident and, after trial, received a jury verdict in the sum of $3,000. He applied for a new trial because of the inadequacy of the verdict, but his application was denied when the defendants consented that the damages awarded to the plaintiff be increased to the sum of $7,500. The plaintiff appealed and we thereafter certified on our own motion the plaintiff's actual expenditures to doctors and nurses and for drugs and hospitalization exceeded $2,200. And although he received most of his normal earnings despite his temporary incapacity, there was a loss of wages approximating $620. While the jury's verdict of $3,000 just about took care of the plaintiff's actual monetary losses, it awarded substantially nothing for his suffering and permanent injuries. Its gross inadequacy was recognized by the trial judge, who pointed out that there was no dispute, but that the plaintiff suffered excruciating pain, and was rendered totally helpless for a considerable period of time. On the 28th of June, 1956, the trial judge wrote to the parties advising that unless the defendants filed a consent in writing that the verdict be increased from $3,000 to $7,500, then the verdict heretofore rendered will be set aside and a new trial granted limited to damages only. The consent was filed by the defendants, and on the 30th of June, 1956, a formal order was entered dismissing the plaintiff's motion for a new trial. The first point which he urges in support of his appeal is that once the trial court had concluded that the damages awarded by the verdict were inadequate, it had no legal power whatever to condition the grant of a new 1116 trial, Chapter 14. Trial upon the defendant's failure to consent to a prescribed increase in the verdict. The term remititure is used to describe an order denying the defendant's application for new trial on condition that the plaintiff consent to a specified reduction in the Jur 5-S award, whereas the term editor is used to describe an order denying the plaintiff's application for a new trial on condition that the defendant consent to a specified increase in the jury's award. While it is now recognized that the two practices are logically and realistically indistinguishable, remititures have been recognized almost ever whereas editors are still outlawed in some, though by no means all, of the states. The English precedents prior to the American Revolution are somewhat obscure, and they are discussed in the majority and minority opinions in Dimmick v. Steed, 293 U.S. 474, 55s.ct 296, 302, 79 L.ed. 603. 1935. There Justice Sutherland, speaking for a majority of 5, with Justice Stone, joined by Chief Justice Hughes and Justices Brandeis and Cardozo, dissenting, held that although remititure is permissible in the federal courts, editor is prohibited by the 7th Amendment. Justice Sutherland in the Dimmick case declined to upset the remititure practice, first approved by Justice Story in Blunt v. Little, 3 Fed.Cas.760. Number 1578, C.C.Mass.L822, and since reaffirmed in many federal decisions. In his dissenting opinion in the Dimmick case, Justice Stone pointed out that the Seventh Amendment was concerned with substance rather than form, and that the Supreme Court had often declined to construe it as perpetuating in changeless form the minutiae of trial practice as it existed in the English courts in 1791. He referred to the many jury procedures, unknown to the common law but now well established in federal practice. He considered wholly unpersuasive the suggested differentiation between the settled remittiture practice which the majority continued and the editor practice which it rejected, and he concluded with the following remarks. To me it seems an indefensible anachronism for the law to reject the like principle of decision, in reviewing on appeal denials of motions for new trial, where the plaintiff has consented to decrease the judgment or the defendant has consented to increase it by the proper amount, or to apply it in the one case and reject it in the other. It is difficult to see upon what principle the denial of a motion for a new trial, which for centuries has been regarded as so much a matter of discretion that it is not disturbed when its only support may be a bad or inadequate reason, may nevertheless be set aside on appeal when it is supported by a good one, that the defendant has bound himself to pay an increased amount of damages which the court judicially knows is within the limits of a proper verdict. Seg.e. Challenging Errors, New Trial. 1117. The majority opinion in Dimock has been the subject of much criticism, and it is doubtful whether the Supreme Court would still subscribe to it. In any event, the Seventh Amendment differs somewhat from our constitutional provision and has no application to proceedings in our state courts. We must look primarily to our own history and precedents in ascertaining whether the highly desirable practices of tetnatitav and editor may be adhered to in our state. The remittiture practice has been recognized in New Jersey since early days. In 1917, the Court of Errors and Appeals had occasion to deal with a negligence case in which the practice of editor had been invoked. Chancellor Walker, speaking for the entire court, had this to say. Gaffney v. Illingsworth, 90 NJL at page 492, 101 at page 243. The power of the court in granting a new trial upon the ground that the damages are excessive, upon terms that a new trial shall be had unless the plaintiff will accept a certain sum named, less than that awarded by a verdict, is too well established to be questioned. It would seem to follow, by parity of reasoning, that when a new trial is granted because the damages are inadequate, the court may impose like terms, that is, terms to the effect that if the defeated party will pay a certain sum, greater than that awarded by the verdict, the rule will be discharged, subject, doubtless, to the power of an appellate court to vacate any such terms when they appear to be an abuse of discretion. KIC we are satisfied that the practices of remittiture and editor violate none of our constitutional interdictions and, if fairly invoked, serve the laudable purpose of avoiding a further trial where substantial justice may be attained on the basis of the original trial. Accordingly, we reject the first point urged by the plaintiff and come now to his meritorious contention that, in any event, the prescribed increase to $7,500 was grossly inadequate and should be set aside. In the instant matter, we believe that the trial judge had a mistaken notion of the evidence which led to his prescribing the scanty sum of $7,500. He stated that the plaintiff was not entitled to a great sum, because he certainly did have a back condition before this accident occurred, but the evidence in the record points to the view that whatever TAC condition the plaintiff had as a result of the 1950 accident had cleared up and had no relation to the very severe injuries resulting from the 1953 accident. Under these highly special circumstances, we believe that the trial court's action should not be permitted to stand and that the interests of justice will best be served by permitting a second jury to pass on the issue of damages. The separable issue of liability was clearly and properly decided against the defendants. Under the evidence it could hardly have been determined otherwise and need not be submitted for redetermination. 1118 Trial Chapter 14. Reversed, with direction for a new trial on the issue of damages. Heho, J. Concurring in result. As is shown H.Y. Justice Sutherland's analysis of the case history in Dimmock v. Steed, there was no power in the English courts at the time of the adoption of the New Jersey Constitution of 1776 to increase, either absolutely or conditionally, the damages fixed by a jury in a case such as this. Justice Sutherland concluded, and with unquestionable authority, that while there was some practice to the contrary in respect of decreasing damages, the established practice and the rule of the common law, as it existed in England at the time of the adoption of the Constitution, forbade the court to increase the amount of damages awarded by a jury in actions such as that here under consideration. He observed that this court, in a very special sense, is charged with the duty of construing and upholding the Constitution, and in the discharge of that important duty, it ever must be alert to see that a doubtful precedent, involving remittiture, be not extended by mere analogy to a different case if the result will be to weaken or subvert what it conceives to be a principle of the fundamental law of the land, and that the power to conditionally increase the verdict of a jury does not follow as a necessary corollary from the power to conditionally decrease it. Since in the case of a conditional remittiture a jury has already awarded a sum in excess of that fixed by the court as a basis for a remittiture, which at least finds some support in the early English practice, while in the second case, no jury has ever passed on the increased amount, and the practice has no precedent according to the rules of the common law. The controlling distinction between the power of the court and that of the jury, said Justice Sutherland, is that the former is the power to determine the law and the latter to determine the facts, and while the remittiture practice in the case of an excessive verdict is not without plausible support in the view that what remains is included in the verdict, along with the unlawful excess, in the sense that it has been found by the jury, and that the remittiture has the effect of merely lopping off an excrescence. Yet where an inadequate verdict is increased by the court, there is a bald addition of something which in no sense can be said to be included in the verdict, and if that be done with the consent of the defendant alone, the plaintiff is compelled to forego his constitutional right to the verdict of a jury and accept an assessment partly made by a jury which has acted improperly, and partly by a tribunal which has no power to assess. Secretary E. Challenging Errors, New Trial 1119. Powers v. ATT. State Insurance Co., 10 Wis.2d 78102 N.W.2d. 393, 1960. Plaintiff received a jury award for permanent injuries in the amount of $5,000. The award was thought to be excessive and called for a remittiture. The question before the state Supreme Court was what standard should determine the amount to which the damages should be reduced. The court noted that since its decision in Himlick v. Tabor, 123 Wis. 565, 102. NW 10, 1905, Wisconsin judges had been required to set damages at the lowest amount that a reasonable jury could have awarded. This rule was contrary to the practice in most jurisdictions, in which the courts follow the practice of allowing the plaintiff the option of avoiding a new trial by remission of the excess above an amount which the court considers reasonable. The court went on to point out that the Wisconsin rule tended to limit the effectiveness of the remittiture practice. We are firmly of the opinion that if the plaintiff were granted the option of accepting a reasonable amount as determined by the trial or appellate court, instead of the least amount that an unprejudiced jury properly instructed might award, the number of instances in which the plaintiff would be likely to refuse such option and elect a new trial would be greatly reduced. The court then specifically overruled Himlick and adopted the standard rule. Notes and questions. 1. For an argument that the practice of remittiture is not constitutional. Under the 7th Amendment, see Thomas, Re-examining the Constitutionality of Remittiture under the 7th Amendment, 64 Ohio St. L.J. 731, 2003. 2. Should a trial court have discretion to set a reasonable remittiture figure somewhere between the highest and lowest possible verdicts? Would it make more sense to require, as the alternative to a new trial, the highest amount an unprejudiced jury properly could have awarded plaintiff. Dauter v. Neek. Michigan Court of Appeals, 1965. 2 Mitch.App. 88, 138 N.W.2, I-501. Defendants operate a beauty shop in Flint. On April 19, 1962, plaintiff was given a bleach and color treatment by defendants without a pre-treatment patch test. Plaintiff received head and facial injuries as a result of the treatment and sued for damages. During the trial, defendants were not allowed to testify as to the standard of care observed by beauty shops in the Flint area when administering such treatment. The jury awarded plaintiff $10,000. 1120 Trial. Chapter 14. Defendants filed a motion for a new trial. Such motion was granted and a new trial ordered, but limited to the question of liability. Both parties appeal. The plaintiff alleges error in granting the new trial as to liability on the theory that the court was correct in the first place when he ruled at the trial that the proffered testimony on the standard of care was not admissible. The defendants allege the court erred in limiting the new trial to the issue of liability on the theory that the questions of liability and damages are so closely intertwined that they should be tried together. As to the plaintiff's claim, we find little merit. His objection is based on the theory that the defendants could know of the practices of the trade in Flint only by hearsay. This is not supported by the record. The record shows that one of the defendants had been in the business for 24 years and the other for 14 years. They had attended conventions of beauticians and observed their practices and said they were abreast of the practices of other beauticians in Genesee County. We agree with the trial court's last ruling that these witnesses should have been allowed to testify and that to exclude their testimony was error, requiring a new trial. Such testimony is admissible because no 1% held to a higher standard of care than the average in the industry. The limitation of the trial to the issue of liability only poses a more difficult problem. It has long been recognized that the questions of liability and damages are so closely intertwined that they may not usually be separated. The only exception the Michigan Supreme Court has so far recognized is in the case wherein liability is clear. A retrial of the issue of damage alone may be permitted. Trapp v. King, 1965, 374 Mitch. 608, 132 N.W.2d 640. In this case, the court reiterated its position that despite the court rule authorizing it, GCR 1963, 527.1, limited new trials are not favored. No compelling reason moves us to extend the rule. The trial judge's opinion states, this ruling, on the evidentiary question, may have materially influenced the jury on the liability issue. It could not, however, by any stretch of the imagination have affected the issue of damages. This bespeaks an assurance we do not share. In the case before us, the damages are not liquidated and the liability was determined pursuant to a trial in which an admitted error touching on liability was committed. Under these circumstances, it seems to us that justice requires that the jury which determines the liability or lack of it should have the responsibility for measuring any damages. Secretary ER.HAT.T. Engine Errors, New Trial. 1121. The trial court's order for a new trial shall be extended to all of the issues. Costs are awarded defendants. Note. Compare the dissenting opinion of Judge Friedman in Hutton v. Fisher, 369 F.2d 913, 920, 3d Sir 1966. As a matter of practical justice, the damage verdict should not be permitted to stand where the question of liability is to be retried. It is the great and saving virtue of the jury system in accident cases that it permits laymen guided by the courts on questions of law to work out in a worldly way an accommodation between the strict requirements of law and their everyday view of justice. That a defendant therefore suffers disadvantage when a trial is limited to Damages and liability is conceded is a fact of life, acknowledged everywhere but in courtrooms. The mutation of a new trial by excluding some of the issues decided is exceptional, and the power to grant a partial new trial must be exercised with caution. Geffen v. Weiner, 100 U.S.A.D.C. 286, 244 F.2d 375, 376, 1957. A retrial of liability will be less than the full rehef the defendants are entitled to have, for its effect will be insulated from the damage question into which it ordinarily percolates. See also Visin IV. Ford Motor Company, 569 F.2d 754, 760, 3d Sir 1977, vacating decision to limit new trial to amount of damages. 6. Requirement and timeliness of requests for a new trial. Reread Federal Rules of Civil Procedure 50 and 59 in the supplement. Unitherm Food Systems, Inc. v. Swift-Ecric Inc., 546. US 394, 126 S.CT 980, 163 L.ED2D 974, 2006. Defendant moved at the end of the evidence under Federal Rule 50, for judgment as a matter of law. The motion was denied, and the case was submitted to the jury, which found for plaintiff. Defendant failed either to renew the motion or to move for a new trial. The Court of Appeals held that although the failure to file a renewed motion for judgment as a matter of law precluded a court from entering judgment as a matter of law, an appeals court nevertheless could grant a new trial as long as a pre-verdict motion for judgment as a matter of law had been filed. 1122 Trial C. H. 14. The Supreme Court reversed as follows. The text of Rule 50b confirms that respondent's pre-verdict Rule 50a motion did not present the district court with the option of granting a new trial. That text provides that a district court may only order a new trial on the basis of issues raised in a pre-verdict 50a motion when ruling on a renewed motion under Rule 50b. Accordingly, even if the district court was inclined to grant a new trial on the basis of arguments raised in respondent's pre-verdict motion, it was without the power to do so under Rule 50b, absent a post-verdict motion pursuant to that rule. Consequently, the Court of Appeals was similarly powerless. He District Court's denial of respondent's pre-verdict motion cannot form the basis of respondent's appeal, because the denial of that motion was not in error. It was merely an exercise of the District Court's discretion, in accordance with the text of the rule and the accepted practice of permitting the jury to make an initial judgment about the sufficiency of the evidence. The only error here was counsel's failure to file a post-verdict motion pursuant to Rule 50b. ID at 404, 126 S.CT at 988, 163 L.ED2D at 986. Justice Stevens, in his dissent, argued that counsel's error did not oust the appellate court of its authority to correct plain error. Murphy's law applies to trial lawyers as well as pilots. Even an expert will occasionally blunder. For that reason, Congress has preserved the Federal Appeals Court's power to correct plain error, even though trial counsel's omission will ordinarily give rise to a binding waiver. This is not a case, in my view, in which the authority of the appellate court is limited by an explicit statute or controlling rule. The spirit of the federal rules favors preservation of a court's power to avoid manifestly unjust results. In exceptional cases, ID at 407, 126 S.CT at 988, 163 L.ED2D at 987. Notes and questions. 1. Does Unitherm affect motions for a new trial under Federal Rule 59? Is it significant that the text of Rule 59 does not require any pre-verdict motion? Does Unitherm bar appeals based on legal error unless a post-verdict motion is filed? The Eighth Circuit has explained. The Unitherm opinion includes language that, when read out of context, indicates that an appeal may never be taken unless a post-verdict motion is filed. A party is not entitled to pursue a new trial on appeal unless that party makes an appropriate post-verdict motion in the district court. However, in addressing SECI challenging errors, new trial 1123. Whether this language extends to all post-trial appeals, courts have uniformly limited it to sufficiency of the evidence. Challenges where parties fail to file a post-verdict motion under Rule 50b, after the denial of a Rule 50a, pre-verdict motion reading. Unitherm more broadly would dramatically alter the well-accepted rule that an objection at trial generally preserves an issue for review on appeal. Linden v. CNH America, LLC, 673 F.3d 829, 832-33, 8th Sir 2012. 2. The time period for filing a motion under Rule 50, 52, and 59 is 28 days after the entry of the judgment. The period is treated as jurisdictional and the district court is without power to extend it. See Hulson Carrot and Santa Fe Railway, 289 F.2d 726, 7th Sir 1961, cert, denied, 368 U.S. 835. 82 S.ct 61, 7L.ed 2d 36, 1961. 7. The power to set aside a judgment. Read Federal Rule of Civil Procedure 60 in the supplement. A. Mistake and excusable neglect. Bryans v. Riviera Hotel and Casino, 116 F.3d 379, 9th Sir. 1997. Plaintiff sued his former employer for unlawful discharge. Carrot. Defendant filed a Federal Rule 12b motion to dismiss, to which plaintiff failed to respond. The court thus granted the motion. Plaintiff, who was appearing pro se and was not proficient in English, moved for relief under Federal Rule 60b-1, on the ground that the court had never informed him that his case might be dismissed and he had failed to notify his translator and typist of the deadline for filing his opposition papers. The trial court denied the Rule 60b motion. At that time, case law had seemed to establish as a per se rule that a motion under Rule 60 could not be utilized to cure a failure to comply with court rules. See, for example, Hulson v. Atchison, Topeka, and Santa Fe Ry, Note 2, p. 1123, Supra. However, the appeals court carried Ted that the Supreme Court in Pioneer INV serves Associates Limited Partnership, 507 U.S. 380, 113 S.ct 1489, 123. Led.2d 74, 1993, addressing a case under the Bankruptcy Act, had analyzed the term excusable neglect and referred to Rules 6b and 60b as follows. Although inadvertence, ignorance of the rules, or mistakes construing the rules do not usually constitute excusable neglect, it is clear that excusable neglect under Rule 6b is a somewhat elastic concept and is not limited strictly to omissions caused by circumstances beyond the control of the movant. East. For purposes of Rule 60b, excusable neglect is understood to 1124 Trial Chapter 14. Encompass situations in which the failure to comply with a filing deadline is attributable to negligence. ID at 392, 113 S.ct at 1496, 123 L.ed2d at 87. The Supreme Court listed 4 factors to be considered in deciding whether neglect was excusable. 1. The danger of prejudice to the opposing party. 2. The length of the delay and its potential impact on the judicial proceedings. 3. The reason for the delay, and 4. Whether the moving party acted in good faith. In view of the Pioneer opinion, the Bryans court remanded the case to the trial court to Determine whether plaintiff's negligence was excusable under all the circumstances. In Pinky v. Andrews, 351 F.3d 947, 951-52, 9th Sir 2003, the 9th Circuit held that excusable neglect to extend the time for filing an appeal was not present when defendant's lawyer relied upon his firm's calendar clerk to calculate the filing date, and the calculation was in error. We do not have a pro se plaintiff as in Bryan's. It is consonant with Pioneer's teaching that ignorance of the rules or mistakes construing the rules do not usually constitute excusable neglect. Here there was ignorance of the rules, compounded by delegation of knowledge of the rules to a non-lawyer for whom responsibility was not accepted. See Simpson-Wood, A Litmus Test for Pioneer, Ethical Considerations and the Delegation Situation, 31 J. Legal Professor 171, 2007. B. Newly discovered evidence, fraud. Patrick v. Sedgwick, 413 P.2d 169, Alaska 1966. Plaintiff brought an action for medical malpractice, alleging permanent physical injuries. The case was tried in October 1961 without a jury. In February 1962, the trial judge rendered findings on the issues of liability. These findings were subject to a lengthy appeal, and it was not until more than 2 years later that the appellate court directed the trial court to enter findings for plaintiff on all issues of liability and to proceed to determine damages. The trial judge fixed the amount of damages on the basis of the evidence that had been presented at the trial and entered judgment on the 12th of January 1965. On the 22nd of January 1965, defendant moved for a new trial on the ground that in 1963 a Dr. Robert Louis had devised a new treatment that would ameliorate plaintiff's injuries and therefore should reduce his damages. The trial court denied the motion. The judge rejected the significance of the new treatment since there was no assurance that any improvement it might bring would be permanent. Secchi. Challenging errors, new trial. 1125. The appellate court affirmed the denial of a new trial with the following explanation. A motion for new trial on the grounds of newly discovered evidence must meet the following requirements before it can be granted. 1. Must be such as would probably change the result on carried new trial. 2. Must have been discovered since the trial. 3. Must be of such a nature that it could not have been discovered before trial by due diligence. 4. Must be material. 5. Must not be merely cumulative or impeaching. In addition to the foregoing requirements, it is established that for any evidence to come within the category of newly discovered, such evidence must relate to facts which were in existence at the time of the trial. We hold, under the authorities referred to, that the trial court did not abuse its discretion in denying appellee's motion for a new trial on the grounds of newly discovered evidence. It is clear from the record that Dr. Louis' discovery of the Teflon technique did not occur until a considerable period of time had elapsed after the case was tried in October 1961. Thus, the Louis technique was not in existence at the time the trial took place, and under the above authorities would not qualify as newly discovered evidence. ID at 177. Notes and questions. 1. The standard for newly discovered evidence is similm under the Federal Rule. In American Civil Liberties Union v. Department of Defense, 406. F.SUTM.2D 330, SDNY 2005, plaintiffs sought documents under the Freedom of Information Act pertaining to the treatment of detainees and O. Interrogation methods used against top Al-Qaeda members. TJE government declined to confirm or deny the existence of any documents on the Crown THA. Their existence was itself classified. The court entered a judgment in Iowa of the government. After the CIA acknowledged the press that IT agents had participated in the interrogation of detainees, plaintiffs moved under Rule 60, B2, and B6, for relief from the judgment based on newly discovered evidence. The court denied the motion. To prevail on a Rule 60(b)(2) motion, the party must show that 1. Newly discovered evidence is of facts existing at the time of the prior decision. 2. The moving party is excusably ignorant of the facts, despite using due diligence to learn about them. 3. The new discovered evidence is admissible and probably effective to change the result of the former ruling. And 4. The newly discovered evidence is not merely cumulative of evidence already offered. Lo. 1126 Trial C. H. 14. Prevail under the catch-all provision of a Rule 60(b)(6) motion, the party must show that the asserted grounds for relief are other than those recognized in clauses 1 through 5 of Rule 60, in addition to showing extraordinary circumstances justify relief. ID at 332. The court found that the media reports would not have changed its earlier ruling, and were merely cumulative of evidence already submitted. As a result, relief was not available under Rule 60(b)(2. Nor did Rule 60(b)(6) provide a catch-all basis for relief, because the asserted grounds for relief, newly discovered evidence, are recognized in Clause 2 of Rule 60, Rehef. Under Clause 6 of Rule 60 is unavailable. ID 2. In Title V. United States, 263 F.2d 28, 31, 9th Sir 1959, Cert. Denied, 359 U.S. 989, 79 S.ct 1118, 3L.ed 2d 978, 1959, appellant sought to set aside a judgment of denaturalization on the ground that some 2 years thereafter the United States Supreme Court, in a different case, interpreted the Immigration Act in such a way as to demonstrate that the original decision in title was erroneous. Appellant relied on Rules 60(b)(4) and 5. The trial court denied the motions and the Court of Appeals affirmed, Rule 60(b) was not intended to provide relief for error on the part of the court or to afford a substitute for appeal, nor is a change in the judicial view of applicable law after a final judgment sufficient basis for vacating such judgment entered before announcement of the change. Assume that the change in the law is announced after the trial court has rendered judgment but before the time for appeal has run. Now should it be open to a party to seek relief under Rule 60(b)? Which subdivision would be the appropriate basis? See Visa in turn. Service Ars NV. JSL Corporation 590 F.Sup.2D 1306, D.Nev. 2008. In Hazel Atlas Glass Co. v. Hartford Empire Co., 322 U.S. 238, 245-46, 64 S.Ct 997, 1001, 88 L.Ed. 1250, 1255-56, 1944, plaintiff brought an action in the Court of Appeals to set aside a judgment rendered against it some 9 years earlier. The first action had turned on the validity of a patent held by defendant. Both the issuance of that patent by the Patent Office and the determination of its validity by the Federal Court of Appeals for the Third Circuit in the prior action had been affected by an article offered by defendant, ostensibly written by a disinterested expert, but actually prepared by defendant's own officials, to the effect that the machine under patent was a revolutionary device. One of the attorneys who presented defendant's case in the first action also had participated in the scheme to prepare and publish the fraudulent article. The Court of Appeals refused to set aside the judgment. The Supreme Court reversed. Every element of the fraud here disclosed demands the exercise of the historic power of equity to set aside fraudulently begotten judgments. This is not simply a case of a judgment obtained with the aid of a witness who, on the basis of after-discovered evidence, is believed possibly to have been guilty of perjury. Here, even if challenging errors, New Trial 1127. Secretary E. We consider nothing but Hartford S. sworn admissions, we find a deliberately planned and carefully executed scheme to defraud not only the Patent Office but the Circuit Court of Appeals. The Circuit Court did not hold that Hartford S. fraud fell short of that which prompts equitable intervention, but thought Hazel had not exercised proper diligence in uncovering the fraud and that this should stand in the way of its obtaining relief. We cannot easily understand how, under the admitted facts, Hazel should have been expected to do more than it did to uncover the fraud. But even if Hazel did not exercise the highest degree of diligence, Hartford's fraud cannot be condoned for that reason alone. This matter does not concern only private parties. There are issues of great moment to the public in a patent suit. Furthermore, tampering with the administration of justice in the manner indisputably shown here involves far more than an injury to a single litigant. It is a wrong against the institutions set up to protect and safeguard the public, institutions in which fraud cannot complacently be tolerated consistently with the good order of society. Surely it cannot be that preservation of the integrity of the judicial process must always wait upon the diligence of litigants. The public welfare demands that the agencies of public justice be not so impotent that they must always be mute and helpless victims of deception and fraud. Notes and questions. 1. Does Hazel Atlas stand for the proposition that a court on its own motion may set aside a judgment obtained by fraud on the court? Was it proper for the court to find that there had been a fraud on the lower court? Different circuits have set out similar tests of what constitutes fraud on the court, meriting the setting a caryatide of a verdict. The Third Circuit, for example, requires the showing of an intentional act by an officer of the court, directed at the court itself, which in fact deceives the court. See Herring v. United States, 424. F.3d 384, 3d Sir 2005. 2. In Peacock Records, Inc. v. Checker Records, Inc., 365. F.2d 145, 147, 7th Sir 1966, Cert. Denied. 385 US 1003, 87 S.CT 707, 17. L.ED2D 542, 1967, the Court of Appeals reversed the denial of a Rule 60b motion as an abuse of discretion. We hold that where it appears that perjured testimony may have played some part in influencing the court to render a judgment, the perjury will not be weighed on a motion to set aside the judgment. This seems self-evident. If the judgment was obtained in part by the use of perjury, then it was clearly the duty of the district court to set aside the judgment, because poison had permeated the fountain of justice. 1128 Trial. Chapter 14. In Philos Technologies, Inc. v. Philos and D, Inc., 802 F.2d 905, 7th Sir 2015. The Seventh Circuit emphasized that the showing of fraud must be clear and convincing, citing Peacock as a case in which the basis for granting the motion was incontrovertible evidence of perjury because the witnesses were willing to testify that they had perjured themselves. ID at 918. C. The independent action to obtain relief from a prior judgment. Reread Federal Rule of Civil Procedure 60, D, and the accompanying 3D NG. Materials in the supplement. Notes and questions. 1. Rule 60, D, is a savings clause that permits an independent action to be brought to attack a judgment that is older than 1 year. As the Sixth Circuit has explained, independent actions for relief under this section must, if Rule 60b is to be interpreted as a coherent whole, be reserved for those cases of injustice which, in certain instances, are deemed sufficiently gross to demand a departure from rigid adherence to the doctrine of res judicata. United States v. Begley, 524 U.S. 38, 46, 118 S.CT. 1862, 1867, 141 L.ed2 D32, 40, 1998, S. Zottberg Hazel Atlas Glass Company v. Hartford Empire Company, 322 U.S. 238, 244, 64 S.CT 997, 1088. L.ed 1250, 1255, 1944. We have set forth the elements of such an independent cause of action. As 1. A judgment which ought not, in equity and good conscience, to be enforced. 2. A good defense to the alleged cause of action on which the judgment is founded. 3. Fraud, accident, or mistake which prevented the defendant in the judgment from obtaining the benefit of his defense. 4. The absence of fault or negligence on the part of the defendant. And 5. The absence of any adequate remedy at law. Mass Liv. Walker, 313 Fed. Apps. 839, 6th Sir 2009, citing Barrett v. Sequoia of Health and Human Service, 840 F.2d 1259. 1263, 6th Sir 1987, citations. Omitted. 2. Many jurisdictions permit an independent action in equity to set aside a judgment. Fraud is one of the substantive grounds upon which relief may be granted in such an action. Suppose that instead of putting forth false information, a party merely conceals facts of which she has direct knowledge. That would have a definite bearing on the outcome of the case. Does this constitute fraud? Does the distinction between extrinsic and intrinsic fraud affect whether the motion will be granted? For an extensive analysis of the Secretary E. Challenging Errors, New Trial. 1129. Basis for Rule 60, D. Motion, see Benham, Twombly and Cal S. Carritald. Finally, put the distinction between intrinsic and extrinsic fraud out of its misery. 64 SMUL. Revelation 649, 2011. Should the plausible pleading standard apply to such an independent action? See Hague, Fraud on the Court and Abusive Discovery, 16 Nev.L.J. 707, 2016.